Everybody, welcome. I had to squeeze you into this room. I hope you're comfortable. I'm Catherine Franke. I'm the director of the Center for Gender and Sexuality Law here at Columbia Law School, and I'm the faculty director of our ERA project, about which this book is not, but the last book was. I mean, it is not as squarely as the last book, but I'm just thrilled to welcome back to Columbia Professor Julie Suk, who's the Honorable Deborah A. Batts Distinguished Research Scholar and Professor of Law at Fordham University. I knew Debbie Batts quite well. She was an amazing, amazing person, judge, academic. We miss her terribly, and what an honor to have her chair. If that's what it is, a research scholarship. And we're here to welcome Professor Suk with this new book that she has, After Misogyny, How the Law Fails Women and What to Do About It. And this builds on a lot of earlier work she did. Last time she was here, we talked about We the Women, the Unstoppable Mothers of the Equal Rights Amendment. There is another book underway. She is a scholarly machine. But unlike a lot of people in the academy who produce a sort of surfeit of work, and it's like, if I had an idea, it's worth publishing, what I find in your work, Julie, is that I just learn new and sort of amazingly dynamic things with each book. It's just, I encourage you to certainly read this, but the others as well, and I look forward to the next book with great anticipation. Part of what is so incredible here, and then I'm going to stop talking and continue talking later after we hear from you, is this incredible distinction that you draw between patriarchy and misogyny. It's a novel and very interesting contribution that focuses on the role of law in both patriarchy and misogyny, and that the ways in which law may vanquish forms of patriarchy, leaving as its residue toxic forms of misogyny, that we need more creative ways to think about how to deal with them than the sort of civil rights paradigm that we have inherited from the 60s and 70s. So she's going to say a bit more about that and then have some questions from my wonderful newish colleague, Claire Huntington, who was formerly on the Fordham Law faculty and is now here wonderfully with us. And they'll have a little back and forth, and then we'll open it up to all of you. Lunch is a little delayed, but it will arrive, and we may take a pause at some point during the proceedings to hear the hopefully good news that the French Parliament has passed a constitutional amendment protecting abortion rights in France that Professor Suk was part of having make happen, a real catalyst to make that happen. And that vote is happening right now. So there's another panel happening right now with something very current and equally important, but we've got our gender justice issue also happening with breaking news in a couple of moments. So Professor Suk, please.
Well, thank you so much, Catherine. I was very excited when the ERA project was started here at Columbia Law School, and I'm really grateful to you for engaging my work and inviting me here to talk about After Misogyny. And it's, of course, a huge pleasure to be reunited with Claire Huntington in discussing this book. So thank you to all. And I guess I'll just start where Catherine left off, which is that actually two interesting, and I would say kind of related, at least related in my work, pieces of news from this morning. News that I think in about 10 or 15 minutes we'll get the official results of, which is the addition to the French Constitution of an amendment recognizing the woman's guaranteed liberty to choose a voluntary abortion. So that's going to enter into the French Constitution sometime this afternoon. And that's very exciting, and it's related to some of the things I'll talk about with the transition from patriarchy to misogyny to eventually, I hope, feminism. And then, but interestingly, I think that the Trump news from this morning is about how to read a very old constitutional amendment that says something about insurrection and was adopted after the Civil War in the 19th century. And whether or not that is going to save this country from Donald Trump. And I think that one of the themes, both in the ERA book as well as this one, is about the need for constitutional renewal and constitutional change, not just at the level of guaranteeing rights, but also at the level of rethinking who holds power in our political and legal institutions. And that is, and I do think that, and the work that I'm doing right now in my year as a visiting scholar at the Russell Sage Foundation is specifically about the problems of having an unchangeable or unamendable constitution for the future of democracy. And that's where After Misogyny actually lands towards the end. So I'm going to try to draw some of these threads together, but I'll also start with the theoretical project of redefining misogyny and the way that political and legal institutions respond to whatever it is we call misogyny. That's the first project of this book. And then the implications of reorienting or widening the lens on what misogyny is for the project of legal feminism and the agenda for legal change, both in the United States and in other countries around the world. So the basic thesis of the book is that misogyny in law is an entrenchment in law and legal institutions of what I call the over-empowerment of men and the over-entitlement of society controlled by men to women's sacrifices and forbearance. And I argue that this is often done through constitutional arrangements, the basic structure of our political and legal institutions, and often through the enforcements of rights and entitlements that may or may not be given constitutional status. And I look to ways in which feminist movements have tried to address the problem. And it comes back to different strategies for undoing legal patriarchy, which is where I start. And so I want to get to this relationship between legal patriarchy and misogyny in the law, which I argue are two different things. So when I say legal patriarchy, I'm referring to formal rules in the legal system that enforce a patriarchal order. I think in US law, it's perhaps paradigmatically expressed in a case that may be familiar to you, Bradwell versus Illinois from 1873. This is a case that enforced and also importantly articulated in a concurring opinion, what's known as the separate spheres tradition in US law. And it involved legal patriarchy, meaning men are the only ones who hold political and civil rights. And women are excluded from the suffrage, women are excluded from legal personhood and legal citizenship. And the justification for that set of rules is that society needs a plan. The legal and political system needs a plan for its continued existence, reproduction. And so the justification for the separate spheres tradition is that women must be excluded from political and legal rights so that they could take up their obligations and natural role as bearers of children, raisers of children, and by extension, just as people who belong within the household and tasks associated with the family and the household. And it bleeds into not just the formal exclusion from legal rights, but the way that the legal system deals with issues like sexual violence and rape. So an important feature of legal patriarchy is also that marital rape is not considered rape because within this order in which patriarchy is the legally enforced plan for the reproduction of society, there's male entitlement to sex, and by extension, male and the society that men control, they have an entitlement to women's reproductive work, which is essential to enabling the survival of society. And so, of course, we have feminism in the 19th century, which has some marginal successes, but the primary strategy for overcoming patriarchy, particularly in the United States, but in many parts of the world, is to introduce norms of equality and non-discrimination in the law. So the idea that women should not be discriminated against in the exercise of legal and political rights, that they shall be equal, have the exact same rights as men. And so then you have this transition from legal patriarchy to legal equality of everyone, regardless of sex, under the law. But I argue that it's that transition that actually gives rise to misogyny. And I describe misogyny as a legal order in which the law doesn't formally discriminate against women. It doesn't exclude them from legal citizenship or the exercise of civil rights, but it continues it through other means to enforce entitlements by men and the society that they control to women's sacrifice and forbearance, particularly in the area of biological and social reproduction. And so when I use the term over-entitlement, I borrow a lot, and I'm not going to go into it so much in this talk, but looking at the doctrine of unjust enrichment in private law, this is a doctrine that says instead, like, you focus on there needing to be some legal remedy or legal response to the fact not that one person has intentionally or negligently injured another, but that one person has actually benefited from another's losses or pain. And you start with that benefit to understand how the legal system should respond. Over-entitlement is that. And if you think about over-entitlement as a public law idea, the idea here is that society is over-entitled to women's work in the areas of biological and social reproduction. And so then we have a lot of legal rules that extract it without compensation. And the most significant example of that legal rule, although there are others, is the restriction or complete ban on abortion. Because restricting women's autonomy in the reproductive sphere is what enforces society's entitlement to that reproductive labor. If she could actually choose not to be pregnant, choose to terminate a pregnancy, choose not to be a mother, that extraction is not possible. And there are other examples we can perhaps consider, but this is the one that I focus on in chapter 3 of the book. And this is where I think that in some ways we've sort of gotten it wrong in the United States in framing the ban on abortion that we're now seeing after Dobbs in many states and affecting millions of women in the United States. The bans on abortion, when we describe them as wrong or constitutionally problematic because they violate privacy and a notion of bodily autonomy, or even that we somehow miss the problem that it's different from other violations of control over your body, and it's different because it's not simply that the state is telling you what you can or can't do, like getting vaccines or wearing masks, just to quote from or paraphrase from Amy Coney Barrett during the Dobbs argument. When the state tells you you can't get an abortion, it's different from that, not just in terms of a degree, but in kind, because when the state tells women that they essentially have to be mothers, biological or social, they're extracting that over-entitlement to women's sacrifices and forbearance, and that's what the misogyny is. And so it includes, but is distinct from, and perhaps greater than, the violence and hatred and discrimination against women that we often associate with the term misogyny. I'm not saying that misogyny is not hatred, but that it's greater and that it involves this over-entitlement, and the over-entitlement of society to women's sacrifices is made possible through legal and political arrangements that over-empower men within a society. And these are dynamics that are sometimes translatable to our anti-discrimination feminism paradigm that we've developed at great length in expanding the Equal Protection Clause to include gender discrimination, but doesn't always capture it. The over-empowerment of men might be a serious problem for women's status and might be a serious problem in terms of its causal relationship to the over-entitlement of society to women's sacrifices and forbearance. But it doesn't register necessarily as discrimination under all the ways in which we think about discrimination. When you have too many men, like many more men in Congress, for example, it doesn't register as discrimination. And so it's important as we think about the real problem of misogyny and its relationship to patriarchy and efforts to undo patriarchy, that misogyny is understood as including an enforcement of that over-entitlement. And so I see the movement, which really, in some ways, well, is triggered and balloons in France because of Dobbs, as a reaction to the Dobbs case. In France, in June 2022, and over the summer of 2022, I got on a call with a few politicians in France who wanted to understand exactly what Dobbs was about because they thought that the proper response was to enshrine the right to abortion in the French Constitution in one way or another. And there was a long political struggle and many compromises made along the way about how that was going to be done. But that's what's being voted on today, essentially an amendment that at least recognizes, although big questions as to what that's actually going to mean, in terms of the law, but at least recognizes in the text of the Constitution the existence of the right to choose abortion as a guaranteed liberty belonging to women. And that's one example I would give of the solution to the problem that I explore in the book, which is resetting the baseline entitlements. That I think that if the problem is over-entitlement, there need to be mechanisms by which the baseline entitlements are reset. And so that amendment in France would be a good example of that. And more importantly, if you're going to see a causal connection, although I think we could debate about this, between the dynamics of over-entitlement that I've described and the over-empowerment of men, there must be some relationship also between resetting those entitlements and who holds power and how power is structured through constitutional institutions. And I think it's not a coincidence in France, where they're becoming the first country in the world to constitutionalize a guaranteed freedom to abort, that comes, this is also the first amendment that they've had in 16 years. 16 years ago, they had a whole package of amendments, but very significantly, one of them was, and kind of pertinent contrast to the US, was an amendment that explicitly authorized the legislature to promote gender parity, to do affirmative action for women with regard to all positions of social, professional, economic, and responsibility, as well as women's representation in politics, which was an amendment in 1999. So there's been an evolution by which the primary question is not only discrimination, but in fact, the question of gender discrimination was a problem for pursuing the rebalance of power, for pursuing the possibility of laws requiring gender balance and gender parity in the exercise of power. And so if we now come back to the anti-discrimination paradigm, which I think has dominated American approaches to legal feminism, and I think the person who's most associated and has been given very iconic status for her work in this area is, of course, perhaps one of the most famous alumni of this law school, Ruth Bader Ginsburg. And as a lawyer, as she pursued the legal proposition that the law should not enforce gender stereotypes, the law should not enforce the legal patriarchy as expressed in gender-differentiated roles within the family. As she did that, what's very interesting about the strategy of comparative law and legal transplant that she followed was that, I mean, by chance, in part because of discrimination against her as a woman, locked out of law firm jobs. She took a job studying Swedish civil procedure and writing a book about it, went to Sweden to research it during a time that they were in a huge public debate about the fact that patriarchy was restricting freedom not only for women but for men, that legally enforced gender roles within the family and gender expectations were oppressive to men as well as to women, because men were expected only to be providers and active in the economic and political sphere to the exclusion of their role as caregivers within the family. And this is a very important insight that she borrows from Sweden, and this is an important insight that goes into many of the cases that she brings throughout the 70s that are important to the project of dismantling legal patriarchy in the United States. But a very often ignored contrast between Sweden and the United States, it's very interesting to note that the Swedish gender roles debate did not lead to an emphasis on anti-discrimination law. It led to an emphasis on restructuring political institutions to make them more representative, and it involved actually abolishing one of the chambers of the legislature that was thought to be not so representative, and then implementing new ways of electing the unicameral legislature to be more representative. Not a perfect analogy, but imagine getting rid of the less representative chamber, the Senate in the United States, and what kind of both constitutional amendments and or public policies would be made possible in the long run if you restructured government to make it more representative. They didn't have gender as a central focus as they did that, but in improving their democracy, they did end up having a legislature that was much more capable of adopting public policies that funded parental leave for dads as well as moms and public child care centers throughout the country, therefore creating a new infrastructure other than patriarchy for the reproduction of society. And the problem, of course, in the United States is that dismantling patriarchal law and saying everyone is equal doesn't necessarily build the infrastructure based on equality. It just dismantles the patriarchal infrastructure, but then leaves it to the market. And once it's left to the market, you see other forces that then basically reinscribe the practices of patriarchy, and then bodies of law that don't seem to discriminate on their face, so bans and restrictions on abortion, and other legal rules that then reinforce the expectation that women perform the reproductive work, both biological and social, for free. So maybe I should just end there. I'm also happy to talk another theme in the book, and I'm happy to talk about it if people have it on their minds. In Ireland, there is a constitutional provision also speaking of women's roles within the home, which I focus a lot on in chapter 6 of the book. There's a referendum this Thursday in Ireland trying to take some of the patriarchal assumptions out of that provision, although a long debate and many compromises about how to do that. So I'm happy to also go there if there's interest in talking about all the different ways that constitutional change can reset entitlements, with a strong recognition that it's actually very difficult also to reset the misogynist entitlements that are in our law.
Great. Thank you so much. Do we want to take a break and let people get their lunch and bring them back to their seats? How do we want to do that? Yeah. Just want to make sure you get a chance to eat, because I know you have classes and whatnot after this. So don't worry, we won't take it personally if you stand up and go grab something. Oh, and then there's.
Has the vote been announced yet? They're still voting? Not
Oh,
yet.
thank you.
Okay.
Yeah.
I was gonna think it's the perfect moment, but no, they said 35, but
Well, I think they expected the speeches to be a lot shorter too, right?
probably.
Yeah. Okay, good. All right. Well, while you're all getting lunch, I know you can, listen as well. So let me just, first of all, really thank Professor Suk for coming to join us today. This is as you know, really, really important and remarkably timely book, and I'm so glad we all have the chance to talk about it. So I want to make sure we save time for everyone to ask their questions. But I will have 3 observations that I want to make, and each one leads to a question for Professor Suk. And we'll see how many we get through, because I want to make sure we can open up the floor. Okay, so the first observation is that Americans tend to undervalue comparative law, but this book shows us why we're wrong to do so. And so I think there are really two reasons why Americans do this, especially American lawyers. The first just stems from, and this is an embarrassing part of our country, I think, a remarkable incuriosity about other countries. We're very navel-gazing here. But the second is that I think a lot of people think even if there was something to be learned, that it just doesn't apply in this country because the political context is too different, the social context is too different, the legal context is too different. And I think one of the real contributions of this book is it refutes both of those, right? So first of all, it shows us that we really must be curious because there's so much to learn. And then it also shows us that even if there are social and legal differences, there still is a lot that's practically relevant. And so that's where I want my question to focus. I think about this sort of the relevance to this country on two levels. One is the level of mindset, and the second is a level of kind of practicality or implementation. So I think one of the huge things the book does is help us imagine different possibilities, right? It is so hard. This is kind of human nature that we get so habituated to what we have that we can't even imagine something different. And so I think being able to just see what is happening, today in France, but in all around the world, in all kinds of ways that Professor Suk describes, there really is a very different baseline that didn't just happen. It came about from a very conscious effort. So I think it really helps us sort of imagine that possibility. So I think it's very effective on the level of mindset. And I think it's also practical on the level of implementation, but that's where I thought Professor Suk could help us kind of flesh that out a little bit. Like, if we want to make this actionable in the United States, and I know you have this towards the end of the book, but this is really an invitation to talk more about this, what would we do? And in particular, how do we try to overcome some of the things that, I don't know if they're unique, but they certainly are very acute in the United States, just in terms of some of the social differences, again, social, political, legal differences, but I'm focused more particularly on the social and political. So just to make this concrete, a lot of the examples in the book, they come from many different countries, but the ones that kept jumping out to me were from Iceland. So everything I know about women's footwear in Iceland, I learned from one article I read in the New York Times. But from what I understand, women in Iceland wear really comfortable shoes. Yeah. Well, it makes sense though, right? And women in the United States, some of us wear comfortable shoes, but many do not. We wear shoes that literally hobble us, right? So, and obviously the two are related. We've got a chicken and egg problem and all that. But so how do we begin to import these ideas when there really are fairly significant differences between the countries?
So, yeah, I think these are really great questions, and I really appreciate that. And I didn't really know about the footwear disparity, but I'm like thinking about Nikki Haley's stilettos, and I'll get back to you. So, I think it is true. This country is very big. The political context is really different, but I think that the first thing that we do need to do, and I think in some ways the goal of this book is modest in that respect, is we need to broaden people's imaginations. And even just knowing what's possible is important to wanting something different. But I think, unfortunately, and this is more connected to the book I'm working on now about how the United States got to a place where we no longer imagine amending the Constitution as a possibility. How did the Constitution become unamendable? It wasn't always unamendable, as the 27 amendments that we have in the US Constitution tell us, but we've certainly, particularly in the last 50 years, gotten to a point where, why is it that the French are saying, let's have a constitutional amendment overruling Dobbs, but we're not really seeing constitutional amendments overruling Dobbs in Congress, although the anti-abortion folks are talking about constitutional amendments protecting unborn fetal life. So one question is just trying to understand, well, what are the dynamics by which people no longer entertain ideas that they think are not possible, and one of the effects of not entertaining, not playing out, not thinking through ideas that you understand from the get-go to be impossible, is that you stop wanting those things. It's very rational, of course. I think Sandy Levinson has talked about this. in the context of constitutional change, that people are afraid to want what they can't have, so they persuade themselves that what they have is actually better than what it is, or that what they could get is not that great. And I think that's actually what's going on with the pretty intense culture of constitutional veneration and veneration of the Founding Fathers that have allowed some pretty obsolete political institutions to survive for as long as they have, despite repeated evidence that they are not working so well. The design of Congress, the completely unrepresentative design of the Senate, and then making that unamendable. So I think the kind of long and difficult answer to how do we make comparative law work is this modest imagination expanding exercise. And then once people are actually at a point that said, well, if we actually could have things be different, we would want to, then we have to think about, well, what are the openings in Article 5 of the Constitution that make it possible to pursue what kinds of changes? And then also, very importantly, at a sub-constitutional level, whether it's through states or through statutory law, what are some ways that we could shift the baselines and shift the policies that reinforce the over-entitlement to reproductive work. And I think we're seeing a little bit of that in the states after Dobbs. We're seeing several states passing, and often through citizen initiative and referendum procedures, the constitutional amendments in several states that enshrine reproductive freedom in some way. Right, so Ohio, there was a big struggle though about that in Ohio, but it succeeded, and California and Vermont, not necessarily in the states perhaps that need it the most, but you are seeing those strategies of trying to reset entitlements, so I think those incremental steps towards reimagining and then using, trying to optimize the institutions that we have. But I don't think that would be possible without getting new ideas from somewhere.
Yeah, great. And like I said, that really is the amazing contribution of the book, is that it gives us those new ideas. Okay, so my second observation is really the importance of continuing to focus on structural solutions. So, Professor Suk spoke about this, but again, another major contribution of the book is how it continues to focus on structure. Like, how is it that men are over-entitled and over-empowered, right? What structure permits this? And the answer is basically men control institutions, particularly our governmental institutions. So the solution from around the world, as Professor Suk said, is to really change that structure of decision making so it's much more inclusive, right? So this is one of the quotes from the book, is that we need to focus on equal power rather than non-discrimination. And again, so many examples. I'll give you another Iceland one, which is that Iceland does gender-conscious budgeting, that when they do a budget, they then sit down and look at the budget and say, what are the ways in which this has gender impacts, right? What are in terms of the allocations, and then sort of to identify that and then make sure it's addressing what are the negative consequences of that. Okay, so this is my question for you, which is, again, sort of for theme up bringing that to the United States, what does it mean to have inclusive decision-making? And I know you're not saying it's as simple as just put women at the table, but I want to put a somewhat finer point on that, which is that there are quite a few women in power in this country who are not doing anything about changing the baseline, right? So let's think about Kristi Noem, who's the governor of South Dakota and is often named as one of Trump's running mates. We talked about Nikki Haley's stilettos, but here we'll talk about the policy. She has on her webpage, on the governor's webpage, it says, "We're blessed with great families in this state. As leaders, I think I can speak for everyone here when I say we value strong families and opportunities for our kids to be successful," right? So that's a nice statement, but what does she actually do in terms of policy? When she was in the U.S. House of Representatives, she tried to repeal the Affordable Care Act. I think we can all agree health care is pretty essential to strong families. And now as governor, she has signed into law one of the most restrictive abortion bans around the country, right? So what do we have to do in addition to, giving women, having more inclusive decision-making that make sure that inclusion then leads to things that actually change the baseline?
Yeah, So I think this is a really difficult problem, and I think that the history of gender parity and the struggle for it and its evolution in other countries, where I would say that most advanced democracies do observe some kind of formal legal rule or party rule that enforces a norm of gender balance in political party candidates to decision-making bodies. And it wasn't without a fight. So I referenced what happened in France, but you also have amendments to the German constitution in the mid-1990s, making it clear, and they had to make it clear because some state constitutional courts, or the regional constitutional courts, were coming out against affirmative action for women in the civil service. And so many other countries struggled with this. If you have a policy that requires an equal number of men and women in positions of decision-making power, is that going to violate the formal constitutional rule that says all persons must be treated equally regardless of gender? So they struggled with that, and I think you end up seeing pretty rapid shifts in countries that adopted gender parity, where you have more women in decision-making power. And it turns out that more women in decision-making power doesn't necessarily mean that you live in a feminist policy paradise the next day. You see women from all sides of the political spectrum. And in some ways that might help to legitimize what the policy outcome is. And so I don't know, I'm not absolutely certain that there is one feminist policy outcome on a lot of these issues, including the ACA, that we would define as the anti-misogynist position. I've tried to remain sort of agnostic. But one thing that you could just see from looking at many historical examples, and a good one is what you see in constituent assemblies after World War I and World War II, which I talk a little bit about in chapter 6 of the book. What you see in constituent assemblies in Germany, in France, in Italy, in many European countries after World War I and World War II, is women represented from all sides of the political spectrum, from like far left communist to kind of far right Christian, or like sort of centrist Christian democratic, but also far right. They seem to converge on the protection of motherhood in constitutions. They converge on, and there are ways that you could protect motherhood that could be distorted by opportunistic politicians, including Adolf Hitler. But the insight that they seem to agree on is related to the over-entitlement dynamic, that if you're actually going to have something that's publicly valuable, which is the reproduction, the birth of children and the raising of children, this has historically been done by women, and there's an importance to putting a public value to it and making sure that women are not disadvantaged or lives ruined as a result of performing that publicly valuable work. And so what does it mean to value it properly? And that's not to say, I think that as long as the over-empowerment dynamic persists and patriarchy persists in the sense that even with a formal legal change, you haven't built a new non-patriarchal infrastructure. If you're going to live in those in-between states, I argue that it's those in-between states that actually are very fertile for misogyny. And I see, I think, unfortunately, when you're in that in-between transition from patriarchy to feminism, perhaps the best way for women to get ahead is by actually capitalizing on anti-feminism. And it's rational, you know, and I think you know, I think you might have friends who joke, you know, if you're a woman who wants to be get a great clerkship and clerk on the Supreme Court, maybe you should join the Federalist Society. And I say that sort of jokingly, but I do think that the dynamic that we see with the women politicians who don't support feminist goals I don't want to claim that it's always false consciousness, but I think we can't ignore the dynamics by which, when you have an incomplete transition, there are obvious political incentives for women within that transition which I call misogyny, to support outcomes that you would not necessarily describe as being in the interests of women overall.
Thank you. I want to make sure we have time for the audience to ask questions, so I'll forbear on my last question. Did you?
It worked, just they voted in France.
Oh, they were. Oh, okay, great. Yes.
Yay! What was the?
780 again in favor, 72 against. So
Wow.
way more.
They needed 3/5.
518.
Wow.
Yeah.
Wow.
Wow.
Wow. Great. So I just want to make sure we open it up and people can have a chance to ask their questions. I might encourage you to use, just because we are in a big room, use your microphone. Who would like to? Yes, please start us off.
Hello, my name is Melody. It's really great to meet you and to discuss like some of the thoughts in your book. And my question kind of is following the international thread. When I'm thinking of structures of power, I think kind of like individual state and then the international order. And so in states making like moves such as France has just done, yay, or in trying to kind of address the ideas that are in the book, how do you think that the international order plays a role where you have like this middling, or if the movement is coming from state rather than from the international part, like how do those things interact, especially for women that might not be able to access like state resources towards the effect of like getting the rights that they deserve?
I understand. You're asking if women can't access the resources of the state in which they live and are citizens, or the place where they reside, how might international organizations or frameworks help them? So I think that certainly a lot of the changes that you see in a lot of places are transnationally engaged. I wouldn't underestimate the influence of CEDAW or other human rights organizations, even if they don't actually have legally binding effect. I think articulating norms has been really important for mobilizing certainly non-state actors going in various places where there are all forms of misogyny, not just the kind that I've described, but just also the more conventional kind of violence and hatred against women. So I do think that it's not, I think there is a tendency in my book to focus on law and the way in which the state extracts. But one of the chapters of the book looks closely at the way that women who had no rights and no power and no access to the state mobilized. I mean, this is a kind of counterintuitive example. This is temperance and prohibition in the United States. They had no rights, they couldn't vote, but it was respectable for them to go out on the streets and protest against drunk men in saloons. And the Women's Christian Temperance Movement is the largest women's organization national. They build all these local chapters, and then they connect and have they're the biggest women's political operation in the country, much bigger than suffrage organizations, because talking about domestic violence and the need for change with regard to things that affect their lives through organizations and not necessarily through the state, particularly when the state is failing them, becomes an incredibly powerful way of getting an amendment which might have been misguided for other reasons and because of the way it was implemented. But it's a really interesting example for seeing how people who lack power find ways of organizing.
Good. What other questions do we have? Yes, why don't we start in the back and work forward? So yes, you please.
Hi, thanks so much for coming to speak. I was wondering whether you could talk a bit more about the specific harm of legal misogyny and yeah, what exactly the harm is, and then maybe also expand a bit on how that reproductive element that you've expanded on is related to physical and sexual violence. And I was thinking of issues like femicide, or sort of, I was wondering how those are related. Thanks.
Great. So I think part of what I'm focused on in the book is to say that misogyny is actually much greater than concrete injuries and harms. That I think that we often think of misogyny as violence against women, hatred against women, and I argue that we need to broaden the lens and think about situations that look pretty banal and nonviolent and still use the same label, misogyny, to describe them. But they're importantly related to femicide in the sense that I see the violence as not just being acts of violence against women because they're women, but efforts to enforce entitlement to women's bodies, and the entitlement to women's bodies is closely related to the expectation that those bodies are to the benefit, not just of the man or woman even, like not just to the person who's enacting the violence, but that somehow control over women's bodies, sometimes through violence, but not always through actual violence, but control of women's bodies benefits society on the whole, because it takes care of the problem of how to reproduce the society. So I think that's where they're connected. So certainly, it's a way of looking at the harm that ties it conceptually to things that we don't necessarily think of as harm or violence. And I would say that we should think of femicide as being more closely conceptually connected to the lack of childcare in society than it is connected to other forms of violence and crime that we see against other kinds of people for other reasons.
Down here, yes.
Powerful scholarship. I was just in DC at an event celebrating Polly Murray, who's a Black queer feminist lawyer, thinker, just genius, responsible for the civil rights movement and the gender justice movement, whose work deeply informed the advocacy of Ruth Bader Ginsburg. Anyway, her image is she's on the quarter now. So this is exciting. That is to say, Congress is acknowledging her contribution to our legal system, and also somebody who created the idea of Jane Crow. And so my question for you, Julie, is what have you seen in, other constitutions that embrace explicit sex equality? How do these provisions embrace or constitutionalize intersectionality? And also, what is that, how does that affect our thinking about something like an equal rights amendment to our Constitution moving forward?
So my answer to that is somewhat complicated. So what Polly Murray said, so Polly Murray is not really, I think in recent years, both scholarship and public attention to Polly Murray has really flourished. And if she's going to be on the quarter, I'm like so excited.
She's on the quarter now. People look for her.
Okay. I'm no longer going to take my quarters to Coinstar, if that's true. Okay, so that's very exciting. What's interesting is that she gave powerful testimony in favor of the Equal Rights Amendment in 1970, which I think she didn't even get to give live. There was for some reason, they didn't actually have a live hearing that day, and then so it was just written testimony. But you could read it. I don't think, it's often ignored, but it's a really powerful piece of text in which she actually says, having pioneered the equal protection litigation strategy that Ruth Bader Ginsburg realized throughout the 70s. But this is in 1970, before that strategy has really come to fruition. But she's done tons of briefs and legal arguments about why sex discrimination should be prohibited under the Equal Protection Clause. And she says, but we still need an Equal Rights Amendment because the Equal Rights Amendment is not actually about non-discrimination. We don't need another constitutional amendment that's going to be about non-discrimination. The Equal Rights Amendment is actually about equal power. And she explicitly says, what I mean by equal power, you know you don't have it if less than 1/3 of Congress is men. You know, like she just gives you indicators in that speech. And she doesn't give you a concrete definition of what equal power is, but she says this is what it's not. And it's the over-empowerment. She doesn't use that word. That's my word, but that's the idea behind constitutional change is therefore not legal and juridical, it's political. We need the Equal Rights Amendment because it is one way, by advocating for it, by getting it in there, by it being there for everyone, including the people who venerate the Constitution, the kids who venerate the Constitution to see, we start enacting a politics by which everyone is equally empowered. And she's talking about men and women in that testimony, but it's really important because she understands the inequality of women to be really importantly shaped by the experience of Black women during slavery. And specifically, if you think about the idea of over-entitlement that's central to this book, there's no better example than Black women during enslavement in the 19th century. That basically, after the slave trade, because of compromises in the Constitution, the slave trade exists until 1808, when Congress finally prohibits the slave trade. It just means that the only way that you're going to continue to reproduce more enslaved people is through the rape of Black enslaved women, and that's to the economic benefit of those state economies and slaveholding men, because their wives don't have rights. But so it's to their benefit, and through both violence. Now we're talking about both violence as well as extraction of reproductive value. So in some ways, that's like the best example of this kind of over-empowerment, over-entitlement dynamic, although all of that is in the testimony, and you don't necessarily see it when you read the words of the Equal Rights Amendment. Equality of rights under the law shall not be denied or abridged by any state or by the United States on account of sex, right? You don't see it there, but that you could find the intersectionality through these narratives in some of the legislative history of the Equal Rights Amendment. And that's something that I think is, if the ERA were to succeed in the United States, I think it would carry with it that important historical intersectional reproductive narrative that you don't necessarily see, the intersectional piece of it anyway, in the gender equality amendments that are in European constitutions that went into law after World War I and World War II. Where their concerns are different. They're related but different. They're also concerned with reproduction, but they're dealing with a practical problem. If you're in Germany after World War I, it's like all the men are dead, and they're only women are. So if you have a legal and social framework that does not allow women to both work and raise children, you are not going to have a nation because all the men are dead. They are not available to do work, and you also have to rethink whether or not you think marriage is essential to having a legitimate family, because there are tons of single mothers, widows, and even if they're not widows, you're not going to have reproduction unless you have reproduction outside of marriage in these countries. And I think that's sort of what's driving the kind of two important facets of what advances the status of women in the 20th century in Europe, specifically a commitment to equality between women and men. And they're explicit. They say equality between women and men, and that's language that it would be much harder to make that language intersectional than the language that is in the ERA, which is, many decades later, on the basis of sex. If we were writing the ERA today, I think we would use the word gender instead of sex, but we're using the word sex now because we're working with what was written in the 70s and trying to enshrine that for reasons having to do with the unamendability, the difficulty of amending the US Constitution. So I think it's true that the equality provisions were always focused on equality between women and men. But that said, if you have an amendable constitution, you can add abortion, and they just did. And in Ireland, if you have an amendable constitution, you can add an amendment that says that marriage doesn't have to be between a man and a woman. You know, you could have same-sex marriage. They did that in 2015. And so I think that in some ways, there might be more potential for going intersectional in places that are more open to formal constitutional change. But in terms of what was actually constitutionalized, I think there is greater potential in the United States if there is a path forward for the ERA.
How are we on time? Do we need to? Okay, so let's do one more question. Yes, right here.
Hi, Julie. I really like your book, and I actually read it on my honeymoon. But if there was one thing that it was often at the back of my mind, which, despite being a very, very proud Irish person, at times I felt like you idealized what the country has achieved in recent times, and that leads me, because you mentioned it, to the care amendment referendum on Friday. And also, there's one about the definition of the family. But for those of you who don't know, Ireland at present has a provision in its constitution that says the state recognises the care that a woman provides to the family as part of the common good, etc. And it essentially has been purely symbolic. That doesn't mean it wasn't deeply problematic, but never created any legal entitlement for those who tried to use it to get the state to pay for care and provide this provision, an entitlement that women did not have to leave the home if they needed to stay at home to provide care. But because there has been, a big surge in changing the Irish Constitution, it's relatively easy to do so. The government has proposed a new amendment to make that provision gender neutral. And what it would instead say, what people are being asked to vote on, is an amendment replacing that care amendment to say that the state will strive to support the care that is provided within the family. And from a feminist perspective, and particularly an intersectional perspective, it's essentially a failure if this gets passed. I don't know if you'd be surprised to hear me say that, but for a lot of the feminist groups in Ireland, and particularly those people with disability groups and others, they're extremely disappointed with the idea of this provision, because what was actually recommended by the Citizens' Assembly was to impose an obligation on the state to provide reasonable measures, a term taken from the South African Constitution, to provide care within and outside the family. Because if the state is striving to support care within the family, that's not creating any restructuring or new entitlement. It's remaining the privatization of care that rests on the shoulders of women by and large. So then to question related to that is more that I'm concerned that when we extrapolate ideas transnationally, including Ireland's abortion referendum, the fact getting to those points of kind of what Ting Ting said and like the whose gets left out, that part of the narrative doesn't make it over. And it's, that narrative doesn't make it over, and that you end up with a situation like you have in Ireland, where people have really campaigned for change but are ending up with a very disappointing option.
And it's a huge question, but I think we're going to have to ask for a pretty brief answer, because we're going to have a class who's coming in right after this. Yeah.
So my very brief answer is that everything that we've discussed, if you're trying to make constitutional change, there are compromises. We could come back to the 19th Amendment left out Black women. in many respects. I won't elaborate on that point, but this is something I'm working on in my next book. Every successful amendment left someone out or did not go far enough. And so then it becomes a political and strategic question. Do you oppose things because they didn't go far enough? Or do you see it as an incremental step on which you can build? And I think, I agree with many of the criticisms of the way that the amendment in Ireland that people will vote on got watered down from what it could have been. The amendment that just passed in France got watered down from what could have been a really strong protection for abortion rights, rather than a pretty weak protection, but a protection in the Constitution, no less. But I think this is the political reality that when you share a polity with people who will not come along with going that far, what's the strategy to get there eventually? But I also agree. I think one of the problems in the United States is that when Roe was the strategy, the backlash that set the nation back on reproductive rights was unforeseen. So I think, we have to keep thinking about that. But often the strategy will not, the decision to not support something because it doesn't go far enough could also end up being a mistake.
Thank you so much. Thanks for the book. Thanks for coming.
Thank you.